Welcome everyone to the second hearing of the Modern Slavery Committee's inquiry into the Ethical Clothing Extended Responsibilities Scheme 2005, New South Wales. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today, and I pay my respects to elders past, present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Dr. Joe McGurr and I am Chair of the committee. I ask everyone in the room to please turn your mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants, and I encourage committee members and witnesses to be mindful of these procedures. Now, to the witnesses, to Ms McPherson and Ms Nguyen, welcome and thank you for making time to give the evidence. Could you each, starting from my left, please state your name and position title and swear either an oath or an affirmation. Perhaps with you, Ms McPherson.
Yes. So I'm Elizabeth McPherson. I'm the National Compliance Officer for the Union, and I will make an affirmation. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be truth, the whole truth and nothing but the truth.
Thank you very much. Ms Nguyen?
My name is Nguyen. I'm the outreach officer. I'm working with the TCF, Textile Clothing and Footwear Union, and Manufacturing Division. I'd like to swear the evidence now about the given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. I'd also like to welcome those joining us in the public gallery today. Welcome to you all. It's great to have you here. I just want to acknowledge your presence. Yeah. Thank you very much for coming. We have a number of members of our committee online as well as in the room here. Now, I wonder if you would like to start by making a short statement, and then we'll have a number of questions and committee members will take them in turn to ask those questions.
Okay, if it's all right, I'll start.
Yes.
So thanks for allowing me to present today. This is a really important issue for the outworkers sitting behind me. I'd like to acknowledge their attendance. In some cases, very difficult for them to attend in something like this. And just on that, I'd like to table the WEIGO report. So it's been circulated to the committee, I understand, by Vivian Wiles, so I'd like to table that. So my history is that I've been in the textile clothing and footwear industry since 1974, starting in footwear, then moving into clothing. In 1985, I was working at home as an outworker. And in 1992, I started in the textile industry as a warper operator. In the union, I've had a full-time role since 2002, and since that time I've been a member of the Home Workers Code Committee, or ECA, as you know it. I've held elected roles since 1994 approximately. I was the president of the Textile Clothing, Footwear and Union of Australia, and after amalgamation in March 2018, held the positions of Victorian State Assistant Secretary in the TCF area and the National TCF Senior Vice President. So just on the report that has been circulated, it explains the legal frameworks and the IR reforms that we utilise for the work we do to protect the outworkers, to ensure that they are employed under secure, safe and fair systems of work. Without the union's presence on the ground and a clear enforcement framework, there is a risk that the laws will not achieve the intended purpose. A key objective in the union's compliance work outlined in the report is to ensure that throughout the entire process, outworkers are protected from intimidation, bullying and the loss of work, which a lot of times they get blacklisted if they speak up. I'd also like to refer to the Ombudsman's report, which was a TCF compliance phase campaign, and that commenced in 2015, which was an education phase, and then a compliance phase that commenced in 2016 with the final report being released in 2019. And some of the findings in there are quite relevant, given some of the other submissions that we've heard, which was that they had real difficulties in identifying outworkers in the supply chains. So the union was the one that facilitated outworker meetings within the different states at the time. And compliance with outsourcing regulation they found was low. Supply chain mapping and outworker engagements was not easy for them to navigate. Record keeping ended up being the main source of their inspections. And like I mentioned, the TCFUA facilitated meetings with outworkers. So in my role as the National Compliance Officer, I managed a team of 9 people nationally and 2 that are based in New South Wales. And 1 is a compliance officer and 1 being the outwork outreach officer. So the way we operate is that the compliance officers start at the top of the supply chain, dealing with labels, brands, fashion houses, and work our way, and they work their way down through the supply chains till we get to the smaller factories and potentially sweatshops and outworkers. So we identify them that way. The outwork outreach officers are on the ground every day, so they're engaging with outworkers through community events, engagement through other activities, and because for the outworkers, outwork outreach officers to do their job, it's a building of trust. So the outworkers need to know that they're meeting with the outwork outreach officers and they're in a safe space. This work is core union work and activity, and we also support the ECA accreditation program through a service level agreement. So companies that apply for ECA accreditation, we're notified through that service level agreement, and we undertake those audits throughout the supply chain. And just to note that it's only based on lawful requirements that already exist in the Award and the Fair Work Act and other relevant legislation such as superannuation, etc. I can speak about the complexities of the supply chain compliance work later if we have time, but I just really wanted to focus on some of the challenges that outworkers have and why it's really difficult to engage with outworkers unless, you know, obviously I've got a team of multilingual people that are from Vietnam in particular, and not only can speak the language but understand the cultural differences and can navigate those. So some of the challenges, in addition to obviously the obvious, which is the concerns regarding wages, paid entitlements and occupational health and safety matters, there's a whole lot of other things that we have to deal with. So obviously they're from a non-English speaking background. They're isolated from other workers, whether they're other outworkers or in-house workers. They've got a limited or no understanding of workplace rights. They're fearful for the loss of work or income if they're seen to be doing or standing up to get those things corrected. There's harassment and bullying by the person delivering them the work. They suffer with work injuries, wrist, neck and their back in particular. Trust is a major issue, like I mentioned, and that takes time to develop. It's not something that happens just with one meeting. There's other challenges, like the person providing them the work may own the house that they're living in or renting. They face financial hardships and stress because they get the work in ebbs and flows. So they might be flat out working 18 hours a day for a number of weeks, sometimes months, and then it dries up and there's no work at all. So they live on their credit cards for that period because there's no income. There's visa concerns and control. So they may not be an Australian citizen or have permanent residence or hold a valid work visa. And if they raise concerns, there's fear of deportation. They face family and domestic violence. Coercive behaviours usually come from other family members, usually male members of the family, and they suffer with mental health issues as well. So we engage with our workers on a daily basis. We have, like I said, a team that does community engagement into those communities. We have contact with them via a quarterly newsletter. We have Zoom catch-ups nationally with the outworkers, Facebook and YouTube channels so that we can get that message out to them. And obviously, one of the things that Viv Wiles had taken on notice of is about what could benefit the outworkers in New South Wales, and one of them is clearly English classes that have support around their particular issues. So not only are they learning how to speak English, but they're also learning about occupational health and safety issues that they face. But it also allows topics around financial matters, financial support, where to go to get the other support that they needed around DV and, the coercive situation that they may be in. So that's what I've got to say today. So I'll pass it over to Nwit if that's okay.
Yes, by all means. Ms. Wynne?
I would like to begin by acknowledging the traditional owners of the land on which we are meet today, and pay my respect to elders past and present. It is a great pleasure for me to be here at the New South Wales Parliament House today. A bit of my background. I'm a refugee from Vietnam. With my brother, when I was 16 years old, we fled out of Vietnam, of our hometown, in 1979. We got picked up by the Dutchman, and we lived in Holland for 8 years. So after I got married, I got one daughter. We migrated to Australia in 1987. My history about work. So I work at home in the TCF industry as an out worker from 1987 to 2009. I became an outreach officer with the TCF UA in 2009. I'm elected as a member of the Committee of Management for the TCF UA Victorian, Queensland, Western Australia branch. I'm the first outworker to hold a union office in Australia. I took part in the union in Senate hearing in 2008. I'm the first outworker to hold a union office in Australia. So in those 20 years, I worked from home. There were no control of wages except working hard and long hours. I had no idea what the outworkers have the right to be treated fairly. Too afraid about losing the work, threatening with harassment to get more work. Facing tough rules if jobs cannot meet the deadline or any mistake could have been compensated out of own pocket and be at retail price, which is enormous. Dealing with middlemen who speak the same language. With a highly skilled base in the sewing industry, I made complex garments for big brands labels. Getting paid from 5 to 7 per garment, it took me about 1 hour to complete, an hourly average of 7 at best. There is no such as superannuation, holiday pay, or sick pay, nor the work cover in case I got accident while working. Most of the time, I had to hide the work stress from my kids. This was not easy, as they soon discovered the different lifestyle from their school friends. And even in the school assembly, the students were shown a video about outworkers, where my daughter recognized people in the video. And only then she started understanding my work situation. Sitting alone in the corner of my garage, I felt isolated. While listening to the SBS radio, I became aware of the union, then decided to step out of my shell and got into the patent making course at RMIT University. Joining the union was a big risk for me, but then I had the big support. It was a privilege for me to speak at the Senate inquiry in 2008. The start of new journey to make a difference and meeting people at the same situation as me was a great experience since I became an outreach officer to build people's trust and rapport in the union and make known the rights of those who work from home. And some of the common stories that outworkers sharing while I'm working with people. So lack of confidence because of no English skills, using children to translate in parent-teacher interview. Majority of outworkers are women. They must sacrifice for their family. Irregular payment. In fact, some employers owe a large amount in wage, never paid. And they have to be in a sham contract. So, outworker achievement during the course of approach, more and more outworkers have been acknowledged as outworkers, receiving hourly wage of skill level 3, written agreement to secure their work. Companies started paying superannuation and all legal entitlements, having proper holiday and spend time with family. Proud to be an outworker. Understand the updates, what the wage coming every year. Improving English skills and computer skill by joining the classes organized by the union. Note that it is the TCFUA and the classes are no longer available. Outworker gathering with their family and outworker on picnic day excursion. Learning new technology such as outworker Zoom meeting and Facebook and other social media. That's it for me. Thank you.
Thank you both very much for that opening statement. We'll take it in turn to ask questions, and I will start. If that's okay. You've outlined a little bit of your experience quite cogently there. I guess we've heard the story of this legislation in New South Wales coming into effect in 2005, and the system set up for compliance through an agreement between the industry and the union rather than enforcement of the mandatory code, so that alternative system. And then what happened was we had the federal legislation that seemed to address this issue of industrial instruments not being right, and perhaps in recent times the current New South Wales scheme falling into a little bit of disuse. In fact, I think we heard that there's only 17 businesses in New South Wales are part of a scheme or have signed up for the voluntary code. So I guess what we're exploring is what is the value of trying to reinvigorate, or the word's been used, resuscitate the scheme. And I guess to understand that a little bit, it would be good to know the current situation for outworkers. I mean, the impression I've got with industrial instruments and the work of the union is that there has been improvements, but it seems to me that there may be much more work to do. So could you reflect on the current situation? And I suppose following on from that, and I think Dr. Kane will probably want to explore this, what would be the value of resuscitating the system at the moment? So perhaps we can just start with a sort of current state of the situation.
So I think the key thing is that the New South Wales legislation starts at the retailer. The legislation in the federal awards and the Fair Work Act start at the manufacturer. So that's a big component for us because the retailer are the ones that can have control. And a lot of them fall through the cracks because they say that they are a retailer and that they don't fall under the category of manufacturer. And that's really challenging for us to try and navigate that. And so the New South Wales legislation means that we can start at the retailer. The current state of outworkers in New South Wales is the same as everywhere else. Where we've been able to identify them, where we have gatherings, where we've provided support and education, there's been a change. But is there still huge levels of exploitation out there? Absolutely. And so it's, even some of the people sitting behind me today, people that are currently in that category. So it's about, because we can't just go in like a bull at a gate and try and fix it, because that puts them at risk. So we have to go through a whole process to make sure that they are protected in that. And that might take us quite a bit of time, but we finally get there. So I think the most significant is the fact that we can start at the retailer level, which is different to the current federal rights.
And just to clarify, what you're saying is where the union is able to identify the situation, you can take action that will
Yes.
help. But I think you're flagging that there's situations, there remain situations which are effectively hidden. I'd suggest perhaps because of the complexity of the supply chain arrangements and so on, and that resuscitating the code might enable those to come to light.
So one of the key things, I suppose, is that once somebody signs up to Ethical Clothing Australia as the voluntary code, it gives us other level of pressure. So if we're going down the supply chain, because generally our outworkers aren't given work from the principal, it's down the supply chain. So where we're able to identify it, we can go back to the top of the supply chain, the retailer, and say, oh, you're aware of this, we need to rectify this. We use that pressure point by the retailer to be able to rectify it. Without that pressure, it takes a lot longer because we haven't got that particular pressure point, and we have to go through a legal framework, and in that we've got to make sure that the outworkers are protected, and they're not identified as the one that's come to us. Otherwise, they're black banned within the industry. So I think the key thing here is more about just making sure that if it is invigorated, it means that people either go, we found last time that more people opted into the voluntary, which gave us an option to be able to scrutinise those supply chains, but also gave us that level of scrutiny and report back to the principal company or the retailer to be able to get those fixed a lot more quicker.
And just to clarify again, so that the operation of the code in that voluntary arrangements makes it easier for you to reach workers and reduces the risk, I wouldn't say limit, reduces the risk of them being, I think you used the word black band or,
Yep.
Okay.
Absolutely,
okay.
yes.
All right, I'm going to stop there. I think we've got a few questions. I'm going to go to Dr. Kane next, and then we'll have some more questions. Thanks very much.
Thank you both for appearing today and for everyone for coming along as well. I have a question about engagement. So you mentioned that you have outreach project workers, I forget the name. I wondered if I could hear a bit more about sort of what that day-to-day work is. And then I guess a related question is, why might other individuals or organisations who, want to do the right thing but don't have that same connection, what's likely to happen if other organisations who do want to help but don't have that engagement come in and try to do something for these workers?
Well, the day-to-day work of Outwork Outreach Officer, which is what the position that DeWitt holds, is basically focused on engaging with outworkers. So there's outworkers that we've helped, and they're on the correct wages and conditions, and it's important that we continue to check on that and make sure that everything's still kosher, particularly when there's a change in the award rates of pay or superannuation. That's another follow-up that needs to be done. But it's also about so we get tip-offs all the time from various areas where outworkers are. Sometimes it's the outworkers themselves that notify us, and so the Outwork Outreach team that's their job, to engage and to build rapport and trust within those communities, and meet with the outworkers individually to bring on board what sort of concerns they have. They then feed that back into the compliance officers, and then the compliance officers as a group will discuss about how we can rectify that. The problem with anybody, another organisation trying to assist, the unions, it's taken, well, I've done this role for 20 years, and, we probably still haven't got it right. But we have made leaps and bounds, like we now can say, there's such a huge amount of outworkers we're now helped and assisted to get their rightful entitlements, etc. And, ones that have identified to us those other issues that I raised, just giving them support and direction to where they need to go to get that additional support, because we don't specialise in all of those different areas. So I think it's really important to have someone that knows culturally the differences, and also can speak their language. We have previously had people that could speak Vietnamese but were Australian born. It didn't work. You've got to understand the actual culture. It's very hierarchical, and so you've got to understand that and be able to navigate those difficulties. They also understand within the family unit how that operates, very different to the white culture. And so to be able to understand that and navigate that without putting the worker themselves at risk, majority of them are women, and so that can put them at risk with their partners or eldest sons in particular. So it's them understanding all that cultural stuff, and also one of the things to point out is that it's not just about the work, it's their whole community. So usually the person that's giving them the work is a senior person within the community, and so if they do something against that particular person, it's not just about, I lose the work, life goes on. Actually fractures their whole community networks.
Mm-hmm. Could I maybe ask Ms. Nguyen, what are the hardest parts of making those connections and getting other workers to trust you?
Yeah, we have to have a lot of visits and a lot of communication. So a lot of people, they don't talk to us straight at the first call or the first visit. So we have to send them information about their rights, but then slowly they can we have to, as I said before, we have to build the relationship, build the rapport. Once they trust us, and then they can tell me everything about, of course, I'm telling you this, but don't make it known to the company. Then we have to, of course, we've got the team, we've got the national compliance officer, and then we have got the whole team to discuss, to have a way to help them. But there are different ways. Like Beth mentioned before, if they're working in the ethical clothing supply chain, it's different. But if they're not, then we have to find different ways to deal. But the hardest thing for me to engage with our workers, a lot of people, they're very fearful. And then they talk to each other, said, if you talk to union, then you'll be in trouble. So we have to make sure that we have to keep our promise. We don't tell anyone. We have to help them instead of make it worse. So we're here to help them. Mm-hmm. So very, very patient. We have to work with them, and if they ask to be met somewhere else rather than at home, because usually we want to see how they operate, so we can assist them about the OHS, and also if they have something to ask at where they work. But so we have a lot of communication, but really patiently listening, and not a lot of talking, but listening to them first, and then what they want, and also we have the team to discuss and then help them. Sometimes I have to take my manager with me, and then slowly they once they trust, then it's a lot easier for us to resolve the problem.
So would it be fair to say to both of you that one of the reasons that you can get this engagement is that you have not a lot of dedicated resources, but dedicated resources who are always available in that space? So it's not someone makes a call and someone who no one's met before comes in. It's that constant contact that allows that level of trust. Would that be fair?
Yeah, it takes time, and yes, it's not a random cold call. It's built up. Usually, we've exposed to the outworkers in their safe space. So it might be at a community event. We always try to attend most of the community events and have a presence, so they get to see us around. So that when we do make direct contact, they already know who we are. Like it's not a bit, it's not as scary for them. And that's why we do a lot of the exterior sort of work to sort of build knowledge of our existence, but also to let them know that we are a safe space too. And sometimes that takes a lot longer than what you would think. But too, over those years, we've built a really strong network in most of the states. So being able to use other outworkers to talk to other outworkers has been one of the valuable keys now. So, I mean, it took a long time to get there, to get that, that base, but now we've got a good base in all the states, so we utilise those. So, I said, we have a Zoom meeting twice a year. We'll use outworkers that they've gone through that process and come out the other side and been so much more happier. And so for them to be able to tell their story to other outworkers that are really fearful and don't know whether to trust us or not, they're the sorts of things that we talk about on the Zoom meetings, or when, like Nwit said, we have get-togethers. It might be a picnic or, something like that, where outworkers can come and bring their families so that they're, again, in a safe space. And that's discussed. So there's never any major pressure put on an outworker, because obviously they're a worker. As a worker, doesn't matter where you're working, you're a worker. So we need to make sure that when we're approaching outworkers, we remember that they're only a worker. And so they need to be respected as a worker, and make sure that we're respecting them about when they're ready to come to us. And so that's generally how it works.
Thank you.
Mr. Donnelly.
Thank you, Chair, and thank you both for coming along, but I can also acknowledge and thank you for the very dedicated and patient work you've done over many, many years for what are well acknowledged as very vulnerable workers in our community. Ms McPherson, can you provide to the committee some insight into, as of now, so we're talking about June 2024, level of engagement with retailers in this state and any other state over the matters that are before us in terms of outworkers, bearing in mind the history that you're very well aware of.
Yeah.
Where are we, a snapshot of where we are today?
Look, at a manufacturing level, we're good, but as a retailer, we're not good. And that's not just in New South Wales, that's more broadly. I think because it's a lot harder to be able to work with a retailer, like I pointed out before, versus a manufacturer. So some of the big retailers, I only identify as a retailer. So we've actually got to go through a legal process to make them realise that they are a manufacturer, right? They fall under the TCF award just like any other manufacturer. But we get challenged about that, and so it's not all of a sudden they go, oh, okay, I understand, I'm a manufacturer. They don't do that. So there's a lot more resources and processes and hoops we've got to jump through to make them identify that they are actually, fall under the TCF award under Schedule F, which is the outwork and outwork provisions. So it's a lot harder. We've got, you know, we in not just in New South Wales but in other states, we've got a number of retailers that are assigned to the code, the Ethical Clothing Australia Code, and so we've been able to deal with it through that way, and it's easy and straightforward. But if an outwork had come to us and said, I'm doing, you know, a label and we know it's, you know, it sells retail, we know we've got a problem before us. I mean, obviously we'll still go through the processes, but it's a lot harder. It's a lot harder.
And just in terms of once, if you're able to secure that cooperation and coming under the umbrella, as you've described, the code, is your judgment is that that's honoured in
Yep.
terms of they do in fact follow through?
Yeah.
And there is
Because
a genuineness about what they're doing.
Yeah. So once it's identified that they actually are captured by Schedule F
Yep.
Under the award, then the legal process kicks in anyway.
Right.
So there's a structure that they must follow under Schedule F. So like I pointed out before, Ethical Clothing Australia accreditation is only based on the award and the Fair Work Act and any other relevant legislation. It's nothing in addition anywhere, except for the exception of WA. So in WA, obviously, non-corporations have still got the state act, the state award. So that the liability of recovery of money wouldn't apply to them, but everywhere else it does. So it's only where they didn't, in WA, they didn't hand over their powers. And it's only for a very small group of people, and we haven't found anybody that falls under the TCF it falls into that category anyway. So majority of nationally, everybody falls under the federal award anyway.
Just a final question, if you don't mind. Forgive me, I don't know the definition within that schedule you've referred to, but does that definition of retailer, is it a broad definition that covers whether we're talking about a large enterprise that sort of runs across all states and territories, right through to maybe a small group that might only have, say, half a dozen stores in a state?
Yeah.
Cover the field?
Yeah. So the problem is that it doesn't pick up the retail. It doesn't. It doesn't say anything about retailers. It talks about the manufacture of goods.
Good. Okay.
Right?
So there's no.
So that's what's the difference between the New South Wales.
Right. So
code,
so that's the key.
Yeah. So the legal system, federal legal system, does not pick up the retail.
Okay.
Yeah.
But I just wanted to clarify this. So it doesn't. The federal legislation doesn't pick up the retailer as opposed to the manufacturer. But
for TCF, yeah. For
TCF,
yeah, for the outwork and around.
But you have pursued a legal process.
Yes.
To do that.
Yes.
And
But we have to do that for every individual retailer.
Right.
Yeah.
So I guess the key issue for the committee is the value of having this code. You mentioned earlier it enables you to identify better where the supply chains are. But it sounds as though it actually makes the process of ensuring compliance better. Is that a fair
absolutely.
observation?
Yes, and particularly with the outworkers, because we've got a bit of leverage. We can go back up to the top of the supply chain, and we can leverage that to get that rectified really quickly.
Okay. Sorry, Mr. Donnelly.
No, thank you, Chair. So that's mine.
I'll just check that Ms. McDonald or Mr. Borzak don't want to ask a question before I go to you, Ms. Volz, and I recognise Dr. Kane, you want to ask another question. Ms. McDonald or Mr. Borzak, do you want to ask a question at this stage?
No,
I think may have some questions.
Yes,
Miss. Sorry.
Go ahead, Ms. McDonald.
Oh no, I don't have any questions.
Oh, okay. All right.
Ms. Sayed has some questions.
Okay, I'm going to go to Ms. Volz next and come back to Dr. Kane.
Sorry, and
Thank you.
excuse me because I'm new to this committee. So, with the process as it exists, that's a hangover from probably the industry 20 or 30 years ago would you say? I actually worked in a clothing factory when I was 16, so I know then we did the retailers. It was a one job for everybody. We'd do Brian Rutschert and we'd do Kmart, but they'd all come through the factory. And so the legislation possibly isn't as is responding to the past rather than the future.
Well, not necessarily. I think it's because it's defined as completely different industries. So retail is retail,
Right, okay.
and manufacturing is manufacturing, and I think that's the divide. So when we're talking to a retailer that actually does give out work and potentially to an outworker, they say that they are recognised and go under the retail framework.
As opposed to what has been happening for 50 years, which is they've actually been contracting the jobs into the industry.
And that continues.
Yeah.
So that it's. I don't think it's that it's a hangover or anything like that. I think it's just that it's completely different industries. So they're sitting over here saying, well, I'm a retailer, I'm not a manufacturer. But we're saying, well, actually, as a retailer, you're actually a manufacturer as well. But you know, we've had challenges in that, and it's not, you know, trying to get them to see that they are actually a manufacturer as well isn't as straightforward as, you know, just telling them.
They're coming in with their exclusive design, their exclusive brand. They're deciding what the pattern and the product is, and the manufacturer is just fulfilling the job that they're actually outlining for.
That's correct. Yes.
And of course, the relevance to the modern slavery situation is, of course, the increasing complexity of supply chains and the disconnected nature of those relationships, which is why this examination is so pertinent, I think.
But I think also there's the other issues I raised around what outworkers are facing. So, you know, some of those challenges around domestic violence and coercive behaviours, you know, the holding of the passports. So all of that sort of stuff,
Yeah, absolutely. Thank you for pointing that out. Dr. Kane.
Just one follow-up question, and it's again because I'm new. Obviously, there's an issue within the Vietnamese community. I used to again work at the Workers' Health Centre at Lidcombe. It was very common amongst Mediterranean communities. Are there any other communities? I'm the member for Auburn, so obviously we see communities shift as war and conflict comes. There's a susceptibility for new arrived people, refugees from conflicts. How difficult is it to grasp that? And is there a growing community, perhaps in the subcontinent diaspora, those communities?
What we've seen is that there is a sprinkle of others, but only a small sprinkle. So there's Korean outworkers, and there's some Cambodian outworkers in New South Wales.
Right.
So the African countries, because it's not a learnt skill in their home country, we've seen them come over and move into our industry, but it's more in...
no, I don't talk to you on a normal line, mate, or my phone.
Robert, Mr. Borzak, you've just come through.
No.
So we've found they go into the more formal sector rather than the informal sector.
Yeah.
At this moment.
Right. Yeah.
Ms. McPherson, I've been doing some work on another committee on procurement, and we've been talking about labour conditions as well. And one of the criticisms of codes, etc., is that it adds more red tape or it's more difficult for business, etc. But just to reiterate, what you seek to enforce is simply legal minimums that every business should be abiding by. So there's no additional...
No, it's just what they would normally have to do under the laws of the land. Nothing more.
Okay, thank you.
I know Ms. Ayed has a question, I think, and I'm sorry, Ms. Ayed, for not asking you before.
That's okay. I'm fine for now. Thank you.
Oh, okay, very good. Keep going, Dr. Kane.
I wanted to ask about your current practice in New South Wales. So there's a compliance officer and an outreach outwork. In terms of the companies that you go and do work with, how do you, given that we don't have the code is here but not operational, how do you target or triage which organisations your compliance officer goes and investigates?
So for our compliance team in New South Wales, they are only dealing with companies that are ECO accredited or pending.
Okay.
Outreach position is different.
Right.
They've got to engage with all outworkers because that's how we find the ones that haven't been identified.
Yeah. Okay.
In supply chains.
Okay, so the compliance office is with those 17 or whoever.
Yes.
And
yes.
then the outreach is everyone else.
Yes.
Right. Okay. Thank you.
Yes.
And is it everyone else?
We're fine, Joe.
Right. So I guess the question is, do you have any observations on what is now required to resuscitate the program? Does it sit with the department to simply get refocused on this because it's already there in the legislation, or are there any other steps that need to be taken?
So what's that?
And also, I guess the other part of that is, I think there was a council that
Yes.
was established.
Yes, the Ethical Clothing Council.
Yes, and my understanding is that's not in existence.
Well,
It's not set up.
It's
Yeah.
not set up.
It's
now.
not set up, yeah. But that clearly was an important part before. It's a question.
Yes.
It
yes.
was.
Yes.
Okay, so re-establishing that's
Yes.
clearly part of
Yes.
what would need to happen, you think?
Yes.
Okay.
Because it needs to be properly managed, so it doesn't fall off the perch like it already has happened. Yeah.
Okay.
Thank you. No further questions.
Okay. Okay. Mr. Donnelly, any?
Just in the context of answering the last question about the past and the operation of the body when it was functional, were you associated? Were you what insights can you provide about how it operated and perhaps the good points and the not so good points about that?
So I can't answer that.
Okay, that's
only
fine.
because that in 2005, the Textile Clothing Footwear Union of Australia had a state branch that managed that independently, and I
Okay.
was in the Victorian branch.
No, that's fine. That's fine.
So it wasn't until really 2018
Yep.
that I became the national compliance officer and dealt
Okay.
with everything nationally.
Thank you.
Okay. I'll just check with Ms McDonald, Ms Ayad and Mr Borzak whether they have any questions. No. Are there any further observations that you have or would like to make?
Well, I just think that it would be really, it's really important for this legislation to be reenacted. I think for all the reasons that I've spoke about, but also for the reasons that, people sitting behind me. We live and breathe this. We know what happens out on the ground, and we do the best we can in trying to identify and assist out workers. The legislation would make it easier to fix it quicker and get those people the rights that they deserve. So, yes, thank you.
Just before we finish, you did make a really interesting observation about the nature of community relationships, and that in some circumstances, I hope I've got this right from what you've said, someone senior in the community may well be the in-between person.
Yes.
And so that when someone speaks up, that fractures not
Yes.
just one relationship, but a range of relationships in the
Yes.
community. So from what you've said, I'm just going to put this back to you. If you had a system in which the retailers, voluntarily work together with yourselves to achieve genuine accreditation and do that in a positive way,
Yep.
then it seems to me that would lessen the impact of a negative interaction there.
Absolutely, because it takes the pressure off the outworker. So
Yep.
it's coming from the top down rather
Yes.
than them identifying it down here and we're working our way up. So it actually gives them a whole other level of protection that isn't gained any other way.
Yeah, I think that's an interesting point. Okay,
Just one quick one.
Yes,
final one.
by all means.
Just sorry to jump in.
Mr. Donnelly.
Do you have any contact association or dealings with the Australian Retailers Association, which is the peak body for retailers?
ARA actually a founding member of Ethical Clothing Australia.
Yeah. And that's, sorry, yep.
Yeah, but me personally, no, I haven't had any.
Because that body has evolved and changed over time and what have you, so.
Yeah, I can't speak on
No,
that
okay,
because
no, that's fine,
I
that's
don't
fine.
know enough about them
Yep.
at all.
No, that's fine, thank you.
Yeah.
Okay, thank you very much. I think we might bring your evidence testimony to a close there. Can I just say thank you very much for appearing today. We might have supplementary questions, follow-up questions,
Sure.
and any answers to that would be included in evidence. Are you happy to
Yes,
provide an answer
absolutely.
to
Yep.
those? Okay, I thank you once again. I think we can get you to withdraw. I'm just checking I don't need to do anything else at this stage in terms of procedure. No. And I realise that we're starting our next session in about 8 minutes, so we might actually can we pause the broadcast for 5 minutes and we'll resume shortly. We'll resume transmission shortly. Thank you. Right, welcome back to the, as I say, the next session of our second hearing of the Committee's inquiry into the Ethical Clothing Extended Responsibilities Scheme 2005. And I'd like to welcome New South Wales Anti-Slavery Commissioner Dr James Cockayne and Ms Justine Conybeare.
Conybeare, yes.
Conybeare, beg your pardon. Welcome. Thank you very much for giving evidence today. Look, I wonder if we could ask you, please, to state your name and position, title and swear either an oath or an affirmation, starting with yourself, Dr Cockayne.
Thank you, Chair. Dr James Cockayne, New South Wales Anti-Slavery Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you. And Ms Conybeare.
Justine Conybeare. I'm a research consultant and a PhD candidate. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much and welcome both of you and thank you very much for giving evidence today. Would you like to start by making a short statement?
Yes, please, Chair. Thank you. Ms Conybeare will start. Ms Conybeare was employed by my office as a research consultant to prepare the submission that you have before you. She will present certain aspects of that submission and then I'll just take a minute or two to present the policy aspects. So,
thank you.
Thank you very much. So good afternoon. I'm grateful for the opportunity to speak today in front of the committee. I'm well accustomed to the risk of modern slavery in the fashion industry, having spent nearly a decade looking at labour exploitation in fashion supply chains. Most recently, my PhD thesis and related research projects have focused on the risk of modern slavery in the industry. The nature and structure of the fashion industry is uniquely susceptible to exploiting workers. TCF supply chains are often expansive, complex, and opaque. Subcontracting is a consistent trait of TCF supply chains in Australia and around the world. Subcontracting fragments supply chains and makes it increasingly complex to monitor and remedy labour conditions. This is further evidenced by the several submissions that reiterate that the size of the TCF industry and the number of outworkers in the industry is not well understood. Yet the industry is heavily reliant on outworkers who are particularly vulnerable to exploitation. Workers' situations exhibit several indicators of forced labour, including abuse of vulnerability, deception, isolation, intimidation and threats, withholding of wages and excessive overtime. Outworker vulnerability to modern slavery is further compounded by their personal characteristics, the nature of the TCF industry and the current environment in which they operate. Outworkers are not easily visible supply chain actors and they are often disconnected from their colleagues as they work in private spaces. For this reason, their work is more easily hidden from inspectors and collective voice is hampered. Since outworkers work in private homes, there is an additional concern that children may be relied upon to complete orders. Since the industry predominantly employs workers from migrant backgrounds, often with limited English language skills, workers are less likely to understand their rights. I also understand that there is a common perception that there are limited alternative job opportunities. So when their rights are violated, it can be difficult for workers to voice their concerns as they fear retribution through job loss, deportation, or other perceived penalties. While we have strong laws protecting workers' rights in Australia, workers must first be aware of their rights to feel empowered to exercise these rights in order for these laws to operate effectively. This is why we need laws such as this scheme to support supply chain tracing, enabling the union and labour inspectors to monitor and engage workers, to inform them of their rights and empower their capacity to exercise such rights. The union has extensive experience and a strong record of supporting workers to voice their concerns. However, the union does face various challenges, and I will pass it to the Commissioner to speak to that now.
Thank you very much, Ms Conybeare. For the reasons that Ms Conybeare has explained, TCF outworkers are rendered invisible to regulators, physically because they're working at home and isolated, economically because they're often working off the books, and politically because they're atomised and often non-unionised. The scheme offered, and we would argue continues to offer, a potentially powerful instrument to render those workers visible to regulators. And that power is in no small part due to the significant role that unions play in the scheme, and in particular their outreach and engagement capabilities, as attested to just now by the evidence presented by Ms McPherson and Ms Nguyen. In the way it combines a mandatory due diligence and reporting scheme with a voluntary code of conduct, this scheme was ahead of its time. It was a forerunner of what is often now in the business and human rights space called a regulatory smart mix, combining different forms of regulatory leverage to incentivise responsible business conduct. But from the particular perspective of my mandate as the New South Wales Anti-Slavery Commissioner, there are 3 issues around the scheme that I think that the committee may wish to consider. First, whatever its promise on paper, the scheme is basically non-operational, and the committee's earlier hearings have explored why that might be the case. What that points to, though, is that the anti-slavery potential of the scheme as it stands is hostage to the political will of scheme participants, including the government of the day. I welcome the indication at the earlier hearing that the Department of Industrial Relations intends to reanimate inspections under the scheme, but for the scheme to come into full effect, the governance system, the council, might also require reanimation by the Minister, and as the recent history of the scheme makes clear, this makes the ongoing effectiveness of the scheme depending on changing priorities of government, business and unions. We think this could be addressed by rethinking the membership of the scheme to include, not to remove anyone, but simply to include the Independent Anti-Slavery Commissioner as an additional participant to serve as a little bit of a watchdog against the same kind of lapse of implementation that has occurred under the scheme over the last decade. Second, the scheme may have the effect of preventing modern slavery by addressing TCF outwork exploitation, but this anti-slavery impact is currently a byproduct of the scheme as designed. It's not an explicit objective of the scheme. The scheme is not framed as an anti-slavery scheme because it predated that work, frankly. And this flows through to the substantive aspects of what is required of retailers and what is not. The information they're required to share speaks narrowly to workplace awards and workplace entitlements. It doesn't go to some of the other factors relevant to assessing the presence of forced labour and modern slavery, such as the recruitment process, the charging of fees for equipment, restrictions on mobility out of the home, and so forth. The regulators here are not regulating for modern slavery risk per se, but for enforcement of the award, which is a narrower set of issues. While government and union officials are undoubtedly highly skilled and bring critically important capabilities to these tasks, such as the involvement of former TCF outworkers and specialist capability to engage vulnerable people, these officials, again, not necessarily trained in or mandated to look for modern slavery risks per se. Regulators are not focused on modern slavery risks under their scheme. It's not the explicit objective of the scheme, although it may have the byproduct impact of helping to prevent modern slavery. And related, the scheme doesn't contemplate how such cases should be handled or reported once identified. For example, where a case of modern slavery is currently identified under the scheme, there's no requirement to refer that person to the federal government Support for Trafficked People program, for example. Again, integrating the scheme with the existing New South Wales and federal anti-slavery infrastructure could be one way to address these lacunae. The third issue is perhaps the most deep-seated. While the extension of responsibilities to retailers was groundbreaking 20 years ago, the substantive obligations created by the scheme are arguably now weaker than what is currently expected under Australia's international commitments of all businesses under, for example, the UN Guiding Principles and the OECD due diligence guidance. What I mean by this is the following. The international standards make clear that the responsibility to respect human rights, including international labour standards, is incumbent on all businesses, not just manufacturers, not just retailers, all businesses. This helps avoid some of the challenges of demarcation about whether a firm is a manufacturer or a retailer, for example, that Ms McPherson referred to in her evidence earlier today. Secondly, the accepted interpretations of these international standards make clear that businesses have due diligence obligations that go beyond asking questions of suppliers and sharing information with regulators. They also have positive obligations to actively create and use leverage with suppliers to address modern slavery risks. That's not reflected in the scheme. They have obligations to provide or enable access to grievance mechanisms to very specific internationally stated effectiveness standards. again, not reflected in the scheme. And while unions and government provide access to certain reporting and grievance channels, that's only part of what is envisaged by the requirement of providing enabling and access to effective remedy under the UN Guiding Principles and OECD's guidelines, and indeed in line with Australia's ratification of the 2014 protocol to the ILO Forced Labour Convention. Similarly, the scheme doesn't cover the retailer's responsibility to provide or enable remedy harms to which they are directly connected. What the scheme provides for is efforts to ensure workers get access to unpaid wages and entitlements. That's important, but it's not the full picture. It doesn't speak to how retailers will ensure victims of modern slavery receive other aspects of remedy to which they might be entitled, such as removal to alternative, less abusive accommodation or living situations, psychological counselling, compensation as victims of crime, medical treatment. So what that means is that to bring the scheme up to date with Australia's international obligations in the anti-slavery area, the substantive obligations on retailers would need updating, and I would argue actually expansion. In the submission, we suggest a way that this could be done relatively straightforwardly, essentially by bringing the reasonable steps standard that the Parliament has imposed on the public sector in New South Wales into the scheme. To be clear, this wouldn't require a wholesale makeover of the scheme, and it would leave government, business and union actors playing the key governance and oversight roles that they play under the scheme, but it would fold in an additional complementary role for my office, and it would integrate the normative standards across the two areas. Finally, the committee's also shown interest in the question of whether or how this model could be applied to other sectors. The short answer here is that it depends on the sector, because the structure of incentives for the use of coercion vary across supply chains, and thus effective policy responses may need to vary in different supply chains. But I would caution that there's a danger in creating individual structures for each sector, not least because it would lead to demarcation disputes, which we heard Ms McPherson attest to earlier this morning, the question of whether the award applies to retailers as manufacturers, since it excludes retailers. A more generalised approach may be needed, but that will probably require reflection by the Parliament on how to combine regulatory levers to foster responsible business conduct more broadly. I'd be very happy to engage in that discussion with the committee or the Parliament today or in the months ahead. Thank you so much, Chair.
Thank you very much for that, and we'll have a number of questions from committee members as we go through, and I will start that process. Thank you very much for that statement, and also for your evidence and for thinking through for us the link of this legislation to modern slavery. So as you've pointed out, we've heard that there's clearly a case for, and the word is resuscitate the scheme, and some of that points to the issues around supply chain and the issues around invisibility and opaqueness that you've talked about. But you've clearly gone one step further here and said, well, how does it link to modern slavery? Now, as I understand it, your suggestions about linking that more clearly in a sort of redone scheme, revised scheme, would be to have perhaps to have the Anti-Slavery Commissioner on a revitalised council. That you would, at the moment, the anti-slavery impact is a byproduct of the scheme, and it's related to the industrial mechanism, so it would be used to get more information in relation to practices, so perhaps the sort of information being provided would be greater. And then thirdly, and I guess this is, as you yourself said, probably the key issue, one of the key issue, perhaps the most difficult issue, is to actually bring some of our obligations under international treaties and mechanisms that we've agreed to into. And I think in that you've talked about extending beyond just award conditions, and talked about remedies around wages, back pay, consultation, counselling services and so on. Those are all, I think the first two steps are probably, I guess as I look at them, not such a big ask, but the third one does represent a significant shift for the retailers, I think. And I'm just wondering, in your experience and your work, and you've done work now for a couple of years here in this space, and more broadly your expertise, how do you think it would be received? How would you go about convincing retailers who don't want to see any more regulation than they need and for whom, modern slavery is already perhaps a vague concept. A number of these businesses don't meet the threshold for producing modern slavery reports and have been kept out of the cycle. How do you think they would react to this? How would you engage them in a positive approach to this?
Thank you, Chair. Our experience in engaging with retailers, including the Australian Retail Association that Mr. Donnelly referred to earlier, is that they're actually looking for greater specificity on exactly what information government wants from them, not less. So they are aware they have to make modern slavery statements under the Federal Modern Slavery Act, and the kinds of guidance that we've recently provided to public sector actors on what reasonable steps to remove modern slavery risks from their supply chains look like here in New South Wales. That guidance has been really welcomed, even by the private sector and retailers, because it provides them greater clarity and specificity as to how they meet their expectations under the UN Guiding Principles on Business and Human Rights and under Australia's commitments under international law. So these are questions that they're already being asked by major investors, for example. So the big retailers in New South Wales are already being asked by investors, what are you doing to address modern slavery risks in your supply chain? But they don't have clarity from government about exactly how they demonstrate that they're doing what they should in this area. So I think actually there would be a level of receptivity in the business community in New South Wales to have this conversation about aligning this arrangement with the broader expectations under federal modern slavery arrangements.
And just to take that a step further, I suppose having it as part of a voluntary scheme of accreditation in which there is their own input, and we've heard evidence that that scheme has worked well with the union in relation to its awards. It also potentially provides a sort of badging or something they can add to the brand for an Australian, product and so on, that might add value to them as well. So that might be another reason for receptivity, is what I'm suggesting, with a voluntary approach as opposed to simply a mandatory code.
Yes. From the retailer's perspective here, this is mainly downside risk. They don't want modern slavery in their supply chain. Certainly they want to be able to sell high quality products at low prices, but they don't want to do that at the risk of carrying a lot of modern slavery risks. So the scheme as it's set up is potentially a very powerful way to empower retailers to get actors in their supply chain to remove that risk from the books of the retailers.
And that's that smart regulatory mix that you referred to.
Yes, the combination of the mandatory extended responsibility scheme and the voluntary Ethical Clothing Australia code is an example of that smart mix.
Okay, thank you. Dr. Kane.
Thank you both for appearing and engaging on this issue, which Ms. Coney-Beare and I have in other contexts as well. I have great sympathy for the idea of any kind of code considering international obligations, but I guess I have a few questions around that, including what are the current enforcement mechanisms for our international obligations? How are they currently enforced on business in Australia or in New South Wales?
So at present, under the existing instance of the Federal Modern Slavery Act, businesses with an annual consolidated revenue of $100 million or more have to report annually a modern slavery statement to the Attorney General's Department outlining against a set of defined criteria what they're doing to identify and address modern slavery risks. That Modern Slavery Act is likely to be reviewed or is being reviewed. A review was commissioned from Professor Macmillan, which was handed down about a year ago, and the federal government's response to that is expected sometime this year, my understanding is. That may then lead to changes in the enforcement arrangements. Under the existing arrangements, the Minister has the power, not yet exercised, to write to a business to indicate, to ask questions about their modern slavery statement.
Okay, so as I said, I have great sympathy for the idea of expanding whatever we do from here and into other industry with making sure we align. But to be frank with you, and I don't think I'd probably be aligned with this, that kind of enforcement regime is not very thorough or very frightening, to be honest, for a business, and only captures a certain amount of business. So, for example, in your recommendation, when you talk about including an obligation to, I think, what are the words, reasonable steps to ensure that goods and services aren't produced as a product of modern slavery. I guess I'm thinking about the tin tacks of it. The ethical code that we have gets very specific about how we find out whether working conditions are exploitative, and there were methods come up with, including considering value and volume, to make sure that we knew what was reasonable productivity. So it's very specific about how we identify that and how businesses can be shown that they're not compliant. I guess my concern with the expanse and the inclusion of parts of guidelines which haven't been, I guess, developed to that level of specificity is, one, it allows for businesses to be, let's charitably call it vague in response about what reasonable steps are. And two, that makes enforcement much harder because you don't have those measurable aspects that you do. And thinking about expanding to other industries, you could do the equivalent of value and volume, for example, and how quick a cleaner has to clean an office, an office setting. So there would be very specific things that you could measure. So I guess a concern that I would love to hear your response to is that enforcement piece with what are still fairly motherhood statements that we would like to see organisations comply with. How would we marry that in a very practical sense in any version of a code?
So I'd make 2 points, Dr. Kane. The first is, I think we need to be clear, we're not suggesting to displace the existing standards through the incorporation of reasonable steps. The point that Ms. Conybeare and I were making in our evidence is that the award and the code and the scheme cover deeply a narrow range of conduct and information related to the award that the scheme allows for the provision of information about. That doesn't cover the field of everything that is relevant to assessing whether modern slavery is present in a supply chain. There are other aspects of conduct in the workplace or outside the workplace that might be relevant to assessing whether a person is in forced labour, to do with whether they're incurring fees outside the workplace, treatment by people outside the workplace, and so on. So the reasonable steps would complement, not displace, but complement the existing normative standards, and by bringing in the expectation of also providing information on these other additional areas of behaviour. The second point I would make is that the enforcement question, I think, is a separate one from the question of the substantive standard against which retailers and their supply chains' behaviour is being assessed. So for Parliament to decide what the appropriate enforcement mechanism is, and I don't disagree with you that the current arrangements at the federal level, I'm on record reflecting this, are not stringent, but there's nothing to prevent this jurisdiction aligning with Australia's international commitments and going further, deeper in a particular area in implementation. That's what we're seeing internationally, that while there's a commitment to and aligning with these shared international standards, jurisdictions are in particular sectors going much deeper in and providing the level of specificity that this scheme already does in a particular area.
So I guess a follow-up question and with the role that you have and the act that we ended up with, you talk about political machinations and where they end up. Well, the particular act that we have is a result exactly of that, which means that you don't, and your office doesn't have enforcement capability.
We do not.
So I guess, and again, just being super practical, we had in here last hearing New South Wales Industrial Relations saying they're ready to go in terms of their role in the scheme. And I guess if we included modern slavery components, we're getting very practical about, we do have that enforcement component sitting with New South Wales IR. Would you anticipate that they would pick up that aspect of it, or would it be a more normative inclusion, that we're including these aspects to encourage businesses, but they're not the aspects of the scheme that we would then seek to enforce? Or
I think it could be both. So imagine a scenario where the scheme is amended so that one of its objectives is anti-slavery alongside the other objectives, and then you include, for example, the New South Wales Anti-Slavery Commissioner in the council. Then what that means is that the enforcement actors, whether it's unions or government officials, the New South Wales Industrial Relations, could turn to the Office of the Anti-Slavery Commissioner for support and advice. So for training to ensure that when they're doing enforcement, they are fully understanding indicators of modern slavery or forced labour that are in front of them. Advice on a case-by-case basis, how does this measure up against the ILO forced labour indicators? You would, in a sense, be mandating the person holding my role and their office to be that additional supplemental capability in the overall governance and implementation of the scheme, not to displace what's there, but to add on this extra wraparound layer of anti-slavery knowledge and capability.
Okay, thank you.
Ms. Volz.
Sorry, I just want to ask some questions because I'm new to the committee. So you're talking about the indicators for slavery. What are those indicators? Just in summary, what do you perceive as the indicators for slavery?
Well, when I referred to indicators, I was referring to the ILO's 11 forced labour indicators, which go to issues such as discrimination in the workplace, harassment, restriction of mobility, debt bondage. That they're articulated and enforced by.
I understand those things. So, I'm the member for Auburn, very diverse community. I have at least 3% of my electorate has households with no income. So when you're talking about indicators, you wouldn't say to a union, this area has a high number of people with no income. Is that indicative? It is more about just the protocols that are laid down by the ILO.
The indicators are used on a case-by-case basis, not at the population level. So they would be looking at any given individual's case, and then there's a methodology for how you look for the presence of those indicators to then assess whether there's a likelihood of forced labour in that particular case. So lack of income on its own would not make out a case for forced labour or any of the other modern slavery offences under Schedule 2 of the New South Wales Modern Slavery Act.
Right. Okay. So in your role, in terms of detection, who's doing the actual detection? I
have a role to promote effective detection, but I don't have an investigative mandate under the Modern Slavery Act. The investigative mandate falls to law enforcement authorities or other regulatory authorities such as Safe Work New South Wales and others. We do receive quite a bit of information from both the general community and people who are victims of modern slavery, and we have referral authority and we regularly pass information on to law enforcement actors.
And how many prosecutions were there in the last 12 months under those?
So prosecutions are generally handled by the federal government under the National Policing Protocol and the National Action Plan on Modern Slavery. I couldn't speak to the number on foot at the federal level, but there have only ever been about 34 convictions for modern slavery offences in the 20 or so years that there have been modern slavery offences on the books in Australia. We get about 340 currently reports to the Australian Federal Police each year, but the best estimates are that there are around 41,000 cases of modern slavery in New South Wales, in Australia. So there's a huge reporting gap.
So you get 340. Do you know if any of those have resulted in prosecution?
So we do not receive those. Those go to the Australian Federal Police. We ourselves...
Sorry, you said you do referrals. They're not your referrals.
They are referred to the Australian Federal Police by a range of actors, State Police, Australian Red Cross, ourselves, others. Yes, we do receive reports of modern slavery. Some of those find their way to the AFP. We've received we've assisted over 80 people directly who've come forward for support and assistance around a year that I've had that capability up and running. I've only been in the role, I'm the first in the role, I've only been in the role for just under 2 years. I only had staff for about 18 months, Ms. Volt, so it's still very much a work in progress developing our capabilities here in New South Wales.
Okay.
Dr. Kane?
Thank you. Thank you both for the analysis in the submission about the code relative to those international schemes. Now, I don't know if I'm going to be putting you completely on the spot, and you both might curse me under your breath for this, but I wondered, we're going to have to come out with recommendations, Chair, from this inquiry. And I wondered if, forgive me, I don't think it's in here, I think I can see the analysis, but I wondered if you'd gone so far as to list the, and you seem to have given it thought, but I wonder if we could get a list of the key updates that you think would be required to include in any resuscitated code for us to consider in terms of recommendations. So if you... I don't think it's in here. I think it's just the analysis of the comparison.
Mm-hmm.
Thank you. Dr. Keane, I can point you to the annex of our submission.
Yep.
Which has a...
Appendix E? Or annex?
Yes, I believe so. Yes, Appendix E,
Annex A.
which has some more information with regards to conformance to the OECD guidelines, comparing the gap between the scheme and the code. I think that could be a really good starting point by means of a list.
And we could certainly take that on notice and come back to you with specification. But as Ms. Connie Beer explains, we'd be starting from the work that she did, lying behind Appendix E.
No, I appreciate that. If there's, and we will obviously take all of that into account, but if there's anything a bit more pointy, that would also be helpful as we finalise things.
So can I just follow on from that with the permission of the committee? So the voluntary, there's a mandatory code, voluntary scheme. The voluntary scheme, as you said earlier, it's a smart regulatory mix. You've got this joint commitment to compliance with the industrial instruments. And you're saying, well, we could expand that to be focused around modern slavery, right? And it means, as you've indicated, Dr. Kane, probably introducing some more specific elements and trying to actually enumerate those so they're not vague, they're helpful. But I mean, that then, who is going to check on those? Do we see that the union will check on those? Will it be up to the retailers to check on those? I mean, obviously we've got to do the standard first, I get that, put them in the scheme. But this scheme, as it currently operates, as I understand it, or we'd like it to operate and used to operate, has the union going into places, engaging with workers specifically around their industrial arrangements, with the agreement of the retailers and the people in the supply chain. That's seen as the powerful part of that. We're now going to add a piece of work there. Someone's got to check on that work. Is that going to be something the unions might consider? Would it be up to the retailers to self-report? How do you think that would that be a problem, asking them to do that, or will it need someone else in that mix, such as the Office of the Anti-Slavery Commissioner? And is that appropriate, or is that just asking too much?
We've got no enforcement power.
I think it's a very good question, because the way the scheme operates is it gives a really strong incentive for people to go through the ECA code.
Yep.
So the first question is, by adding, where would we add work? Would we add work actually in the code and in the enforcement of the code? And if that's what the Parliament adds, that's a discussion to have with the ECA as a voluntary space. But the other way to do it would be to say it's not for Parliament to interrupt the way the code operates. What we're trying to do is add a component over in the scheme part of the process. Then it's open to the Parliament to design how that extra work would be done, and it could be done by government officials, as I said, through the way that that New South Wales Industrial Relations exercises its powers of inspection, engagement, information collection. It could be done through the unions, not under their ECA mandate, but through the scheme mandatory aspect of the work. It could potentially be done by my office. In any of those cases, there's going to be a capability and resourcing question, no doubt. Extra work means extra resourcing.
Question on that. Literally thinking about this as we're speaking and trying to brainstorm and work through it as we go. So with the scheme, retailers are required to report to provide those
Yes.
regular reports
Yep.
to New South Wales IR. So potentially an inclusion in that.
Exactly.
So that deals with those who haven't opted for the voluntary side of things. So those that don't opt for the voluntary side of things, who frankly would be the ones that we would be more concerned about generally because they don't have that tight audit, which is likely to identify. So it would be feasible that in that reporting system and what's required, which would probably need updating, that's something that could be included and does then get reported to New South Wales IR, which then in consultation with you, the skills could be developed about how to assess that.
Exactly. And I think if I picked up earlier on a question you asked an earlier witness, Dr. Kane, the gathering of that information on an aggregated level might then allow for strategic targeting of use of limited enforcement capabilities to parts of the supply chain that appear to be most risky. So my office could assist, that's probably how I'd put it, assist New South Wales IR in the analysis of that information and in upskilling their teams on a continuous basis to be able then to inspect effectively, if that's the correct term. I'm not sure if that's the correct term.
Yep. So focus on the mandatory code, and then that provides the direction for the voluntary system and the council to start working that through. And you may even leave that work or leave it up to them to start working that through themselves. But there will be a resource implication. Now, I do know that Mr. Ayed would like to ask a question.
Ms. Ayed.
So, and I apologise, Ms. Ayed, but I think you might have had your hand raised, but I can't see it from here. But over to you.
Okay, thank you, Ken. So my question is a follow-on from the member for Auburn's questions. I'm interested to know how can the Anti-Slavery Commissioner's powers under Section 27 of the Modern Slavery Act be effectively integrated into the scheme, and of course with the goal for the scheme to be more effective and to better mitigate the risks of modern slavery in the TCF industry. And I'm happy for this one to be taken on notice if need.
Thank you. I will venture an answer now. I might need to take it also on notice, but the short answer is Section 27, which you very helpfully, Ms. Ayad, drawn our attention to, is the Code of Practice power, the power to issue codes of practice on these kinds of issues. We're currently exploring issuing codes of practice in relation to two other industrial sectors, one dealing with renewable energy value chains, one dealing with investment, asset management and lending. That power allows the Anti-Slavery Commissioner to develop codes or indeed refer or incorporate other existing codes into a New South Wales Code of Practice, but it leaves blank, frankly, the provision leaves blank how those codes are then enforced. So that's a central question for development with those affected actors in any of these discussions. What I think this means for this sector is there would be the possibility to rely on that provision in bringing the New South Wales Anti-Slavery Commissioner into the picture here. But what I will take on notice, if you don't mind, is to think through the practical implications of reliance on that provision. It's not obvious to me at first instance, but I and my team would be happy to give that further thought.
Okay, wonderful. Thank you.
Do you have another? Dr. Kane.
Is that okay? I guess now it's getting a bit more specific about your role in terms of government supply chains. And as you know, I've got a procurement inquiry at the same time looking at what we might be doing there. So I wondered, if you could speak a bit more about your considerations about the textile supply chain, uniforms, etc., in terms of your role in the government sector and whether this scheme assists or could potentially assist in any way there.
Yes. So I believe I will have the privilege and opportunity to brief the committee on the work we've been doing to provide guidance to the public sector on these reasonable steps questions later in the year. In brief, one of the tools we provide to the public sector now is a inherent risk identification tool that allows public buyers to assess the inherent modern slavery riskiness, to coin a term, of purchasing particular types of products. And uniforms, which is how these things show up in the New South Wales government procurement taxonomy, have been identified as high risk because of the inclusion of commodities such as cotton, which are known to have strong links to forced labour in particular in various contexts. So what that means is it puts the public buyer on notice that they have to take certain heightened due diligence steps, and we lay those out in great detail in the guidance in order to manage that risk. It does not work as a thou shalt not buy arrangement. It sets a standard for the due diligence steps that need to be taken to effectively manage the risk. The buyer can still buy that product just as they can enter into a high risk procurement transaction for, say, a transport infrastructure development where the risk comes from financial risk. They can still do that, but they need to put certain safeguards in place. The same here for modern slavery risk. The opportunity here might be to create a crosswalk between what is the guidance that we provide to public buyers on how to manage risk in the TCF supply chain and the existence of this scheme. So it could be that we indicate to government buyers that it's open to them. It's not in my gift to mandate it, but it would be in the gift of the procurement board, for example, to mandate it. It's open to buyers to participate in the ECA or to give preference to retailers or to suppliers that are somehow participating in the ECA code or compliant in some way with the scheme. I'd need to think about the technicalities there and could take that on notice if useful, but that would be the basic crosswalk that would be open, I think.
Thank you, I appreciate that.
And could arguably provide an additional incentive to comply with the code in terms of...
Very much so.
Yeah. And that would be an example of how the New South Wales government would be using its significant procurement capacity.
And an interesting question, if I may, Chair, might be for the committee to ask New South Wales Procurement what percentage of TCF suppliers, so uniform suppliers to New South Wales Government, are currently ECA participants or members.
I think we asked that of AFC at my hearing yesterday, and I can't remember if they were taking that on notice, but I think that information will be available to us. Yeah.
If not, we should certainly note that as a question, actually. Given that there's only 17 in New South Wales, there may be a bit of a gap there, I think. Okay, I'm just going to check with Mr. Borzak and Mrs. McDonald as well as Ms. Ayed online. Would any of you like to ask a question? I know you've been listening intently. Sorry, Ms. McDonald.
No, I don't have any questions, but thank you for asking. Happy to continue listening. Thank you.
Thank you. Ms. Donnelly, you okay? Ms. Volz?
Yes, I'm fine.
Dr. Kane?
Thank
right.
you.
I'm right too. So thank you very much, Dr. Cockayne. Thank you very much, Ms. Conybeare. Really appreciate your evidence. We've got a couple of items that you're going to come back to us. We may have some further questions. Your answers form part of the evidence. And it sounds as though you would be prepared to provide those. We've got a 7-day turnaround on those. So if you can just be mindful of that once you get the transcript as I understand it. Okay, well on that note, I think we'll bring the session to a close. I'm just checking if there's anything else I have to do or say. No, once again, thank you very much. And we'll finish the broadcast at this point. Thank you.